I'm going to now introduce Mr. Jeffrey May, who will be leading today's discussion. Go ahead, you can take it away now.
Thank you. So greetings, everyone. Greetings. So we want to, again, welcome everyone actually to this wonderful conference. I'm very, very humbled. Thank you. I want to thank Ms. Beverly. I also want to thank Mr. Enrique for actually, and the City of Austin, as well as Patrick, the City of Austin, as well as Patrick and Mrs. Nade, Mr. Bryant, for actually bringing me here from the Texas Workforce Commission. Just a little bit about who I am. Let me just move this up a little higher so you all can hear. Although I do have a loud voice and I do talk a lot, I'll just tell you a little bit about who I am and why I'm here. So as it says, I'm Jeffrey May. Oh, I can turn this one off. I'm sorry about that. I'll turn it so that there's no feedback. Actually, I'm gonna give it to you so that I don't mess things up. Oh. I didn't do it. It wasn't me. It wasn't me. It wasn't. I promise. I assure you it wasn't me. So, as has been said and as has been kind of remarked about, I'm Jeffrey May. Hold on. Can you hear me? Testing 1, 2. There we go. I'm Jeffrey May. I'm AKA the bow tie guy, and I should say the bow tie guy in fair housing, because there are many bow tie wearers, ladies and gents that wear bow ties. However, I'm the bow tie guy in fair housing. I'm with International Development and Planning. However, what's most important about me, I guess, is that I am here to serve all of you who are members of the fair housing infrastructure of the United States. I'm here to be of service to you. I say that because I am the lead faculty member for one of the 2 lead faculty members for the National Fair Housing Training Academy. So if you've ever actually gone on to any of the trainings that we've actually hosted through the National Fair Housing Training Academy, and that's HUD, FHEO, Fair Housing Equal Opportunity Training Academy, we are the lead faculty, myself and my business partner, Mr. Michael D. Mitchell. As a firm, International Development Planning, we're a technical assistance provider for HUD. So we have been this is a designation that's really nice for us because we have been a sub of all the prime contractors underneath this space since 2009. What we have been for them is their subject matter experts on fair housing, all things fair housing. I have over 27 years in fair housing. I find that hard to believe myself. In fair housing, so I'm still a young man. That being said, but it was in enforcement. So that's gonna be the orientation in which I'm gonna be speaking to you all today, because that's kind of how I see the world. As a TA provider, we actually provide training. As I shared with you all, the National Fair Housing Training Academy. We also provide technical assistance in the form of assisting those entities, that cities, that states, that's also local governments that are substantially equivalent underneath the Federal Fair Housing Act. So we'll talk a little bit about that, specifically 24 Code of Federal Regulations, CFR Part 115. So that deals with the FAP program, and that's what we're gonna be talking about today. However, aside from doing the training, we actually do a bit of research. So we work with your counterparts. So I'm gonna do a little polling because I wanna find out who's who and who's in the room. I know some of our dear friends who I'm familiar with and their wonderful faces, I know who they are, but I wanna get a better feel of who you all are, because my remarks are gonna surround conciliation. That's actually a part of the investigative administrative process. When a complaint is actually brought, there's actually a requirement underneath the Act, as also the Code of Federal Regulations, that actually require conciliation to actually be offered. And it's something that you're gonna hear me talk a bit about. So that means if you're filing a complaint, or if you're investigating a complaint, those complainants that actually come to you have to be offered conciliation opportunities and efforts throughout the process, which we'll talk about. So if you are not with a Fair Housing Assistance Program or Fair Housing Initiative Program, you're with a housing counseling agency, you're with a disability rights group, you're with a legal services, or a FIP, a Fair Housing Initiative Program, you can actually be a part of the process, and or your client, because your client is why you would be a part of it typically, not exclusively, but you and your client can actually be a part of the conciliation process. And so we'll talk more about that. But again, as I shared with you, it's a part of the administrative process. In terms of the research that we do, we actually draft what are called analysis of impediments or assessments of fair housing. So there is a rule that is supposedly imminently coming out called the Affirmatively Furthering Fair Housing Rule. That rule is actually codified in 42 United States Code 3608E and D5 of the Fair Housing Act. And so in that part, we also need to say, I'm not an attorney. I love the law. I'm not an attorney. I'm an investigator by training. And I should say this, in order to love the law, you do not have to be an attorney. In order to practice the law, you must be an attorney. So that being said, it's our responsibility, all of us, whether you are part of the fair housing infrastructure or not, really, general public, we all need to be familiar with the Fair Housing Act and be comfortable with sharing that information, because these are rights that all of us enjoy, and that protection, that federal protection exists. But you also have the state law here that also provides the protection as well as the ordinance that is actually covered by the city of Austin as well. So again, being aware of those laws, being aware of those ordinances and those state statutes, that's incumbent upon all of us, whether or not we're housing professionals or we are the general public or assisting the general public. It is incumbent upon all of us to become familiar with the fair housing laws and the substantial equivalent of those laws at the local and state level. So as a part of the analysis impediments, we draft, assist in drafting, or provide technical assistance and guidance on the production of those documents. That rule is imminent, so I do want you to just, look out for this. It's said that it may be coming out real soon, but I can't speak to that. I can just say in which, when, if, and when it comes out. Just be aware that the bow tie guy said you need to read it, you need to be familiar with the Affirmative Furthering Fair Housing, because that part of the act deals with the governance, deals with local land use, deals with what we were talking about, housing building codes, not directly in terms of housing building codes, but it actually deals with local governance and the built environment and land use. So we work with public housing authorities, we work with cities, we work with states, assisting them to put together their analysis impediments or assessment for housing. We also work with the industry. So that's something that, as a person who used to be solely on the enforcement side, now I'm actually a bit on the compliance side. So we work with banks, we work with other lending institutions that actually provide mortgages underneath the Home Mortgage Disclosure Act, HMDA. We analyze those data and we assist them to actually make sure that they're compliant with the law. But that being said, I want to now move into telling you a little bit about us and me. I want to move into the crux and why we're here today, which is we are going to be talking about conciliation. So some of you actually may not be familiar with conciliation. Those of you who are working at a Fair Housing Assistance Program, FAP, you should be, because that's actually part of your work share agreement with HUD's Office of Fair Housing Equal Opportunity. It's a part of the process. It's not the only part, because actually your responsibility principally, if you're at one of those agencies, is to intake those complaints that actually are jurisdictional, meaning that there are 4 elements of jurisdiction that have to be met: standing, timeliness, respondent and dwelling covered, and subject matter. So once you have a perfected complaint and you move it into the process, part of investigating that and moving through the administrative process requires that the person be offered the opportunity to conciliate. And we're going to talk about that, because the conciliation is a lot of the dispositions of a lot of the complaints that actually are resolved through the administrative process. That's not only through the FAPS, Fair Housing Assistance Program, which many of you are members of, which I'm going to get to that poll question in a moment, but also HUD as well. HUD, Fair Housing Equal Opportunity, those equal opportunity specialists, that needs to be a part of the process. And in fact, you'll see if you look at the annual report, the HUD Title 8 annual report, no, it's actually HUD Fair Housing Equal Opportunity annual report, you will find that there are a lot of complaints in terms of the disposition of being resolved through the conciliation, that you have a significant number of complaints that are resolved that way. So you have the opportunity for a person, if it is a perfected complaint, to arrive at a reasonable cause. That means that there is a finding, that there's finding that the law had been violated, either local ordinance, state statute, or the Fair Housing Act as amended. There also is the option, if the evidence does not support it, that there can be a reasonable no-cause determination that can be arrived at. However, you're going to find that a significant number of complaints are actually resolved through the conciliation process, which is really bringing the parties together, and it's a bit more than this, but bringing those parties together to try to determine how can we resolve this complaint so this can actually move forward, that we can preserve the relationships to the extent that we can, avoid exhaustive and protracted litigation, and be in a place in which the respondent and the complainant can actually continue in their housing provider and tenant, or it may be mortgage loan offer, mortgage lender and borrower relationship, or home buyer as well as real estate professional relationship. So you want to be able, that's something you're going to find that conciliation does, but I'm going to pose that question to you in a moment. So back to the poll question. So I do want to know in terms of who's here so I can customize my remarks to that. As if you haven't noticed yet, I can talk. So, so I'll take a breath. And in that breath, I just simply want to ask, how many of you, by show of hands first, are from a Fair Housing Assistance Program, a FAP? So everyone at that table should be raising their hand. Everyone at that table should be raising their hand. And thank you as well. So, and thank you, City of Austin. Those of you who are present, who are not FAPs, if there are any FIPS, Fair Housing Initiative programs that are present. FIPS. Those are typically not-for-profit agencies that have received funding from HUD's Office for Housing and Equal Opportunity to conduct investigations or education outreach. Testing is something that they do a lot of. Testing, mystery shopping, I'll give a quick definition. Testing, mystery shopping is a social science that's evidentiary tool used to document the behavior of a housing provider at a moment in time. I share that with you because it's a powerful tool for investigative purposes and really can actually assist in those cases in which discrimination may be hard to find and hard to document. So others, how many people are from a disability rights organization or advocacy organization? Excellent, thank you. How many are from a legal services organization? How many are from a housing counseling organization? Okay. How many are just the general public and I'm interested in getting information? All right, thank you. And lastly, how many are from a shelter or a group home provider, any congregated living in that respect? Okay, the reason I asked about that latter. Public Housing Authority, yes. Public Housing Authority, okay, there you go. So I will point out, good, thank you for that. I will point out that the Housing Authority and all those others that I mentioned, not-for-profit agencies, housing counseling agencies, disability rights group, legal services groups, housing shelters, you can actually be complainants, aggrieved persons, aggrieved entities. So not only the individual persons that you all serve can be considered aggrieved persons, I mean, that's the person before you file a complaint, but your agency is in a position, if you come across an act of housing discrimination, that prohibits you from being able to assist your clients in being placed in respective places. I would say about the public housing authorities, you're in a very unique position because you're a government entity, a quasi-government entity in some instances. So you may be familiar with fair housing because of a compliance at times, compliance issue. You're also subject to not only the Fair Housing Act, but Section 504 Rehabilitation Act of 1973, which is what was being remarked about by the previous presenter. So I share that because I want to be able to touch on all of the needs of everyone that's present, because when we're talking about conciliation, this is the place where many of the complaints, a large number of complaints, are resolved through that process. They're resolved through that process. So with that, we're going to talk about, and I'm going to watch my time as well, because like I said, I can talk. We're going to be going to 4:30 until Damon pulls me off the stage, or that. We're going to be talking about this, the mandates to conciliate. Okay, because this is something that's actually very unique. It's spoken to in the Act, in the Fair Housing Act as amended. It speaks to conciliation. In fact, as a matter of fact, if you do a word search of conciliation in the Fair Housing Act, it comes up 23 times. So again, that's really important. I am aware that many of you actually have a mediation program. And again, that's mediation, again, doing something very similar to what takes place in the conciliation process. However, conciliation has its own distinct differences, which we'll talk about in a moment. The principles of conciliation, the role of the conciliator, the conciliation process, relief that's available through the conciliation process, elements of a conciliation agreement, which we're going to talk about. As you can tell, we have a longer training that we actually do, not through the National Housing Training Academy, but through my firm, International Development and Planning, I'm a member of, in which we actually take you through the process of being a complainant, being a respondent, and being a conciliator. So it's I think, a very wonderful, robust exercise. I have to remind the participants that this is only a mock conciliation, that they are not to choose sides. The next time you see the person, you're not saying, you still owe me. No, it's supposed to be a mock conciliation, but you can see how when people, I feel like that's representative, indicative of how effective the training is, that people are taking on these mock roles, are really getting into it. But again, there's a much larger training that we actually do that on this. Elements of conciliation, as I remarked about a moment ago, documenting of the conciliation and ensuring justice and public interest in the process. So I'm going to kind of start with the beginning and talking about the ensuring justice in the, there we are. Ensuring justice in the public interest process and public interest. So those of you who actually, I'm not going to ask my friends, none of my friends to tell on him, her, or themselves, but when the complaint comes in the administrative process, and so I do hope that everyone is familiar with that City of Austin, as well as Texas Workforce Commission, are FAPs, they're Fair Housing Assistance Programs. They can actually receive complaints, investigate complaints, and if they find that there are violations of their respective ordinance or state statute, they can actually prosecute and actually arrive at what's called reasonable cause determination, and they can actually then go into state court or your municipal court to be able to enforce your respective laws. So that means that you have protections, and these are unique protections because all states and jurisdictions do not have this. There are not FAPs that are in all states. In fact, there are only 35 state FAPs in the country. So again, you're in a very unique position. That's a very positive position because that means that the rights that are protected underneath the state statute and the city's ordinance are there. That means that those protections exist. And you can imagine, and we don't have to imagine we don't have to let our sociological imagination run very far, because prior to the Fair Housing Act being passed, we were in an environment in which fair housing rights didn't exist per se. They didn't exist. We had some laws that were protections underneath the Civil Rights Act of 1866. That's right, the bow tie guy said Civil Rights Act of 1866. But it was not as robust as the laws that you enjoy underneath your state law and underneath the City of Austin's ordinance as well. So really be proud of that. So that in itself, when I say starting off with the discussion about justice, that's important because when we do these analysis of impediments or assessments of fair housing, that's one of the first things that we're looking for. We're looking to see, do you have an established law that actually provides protection for those persons in your jurisdiction? And then if you do you have a Fair Housing Assistance Program, or do you have a FIP program? But most importantly, a Fair Housing Assistance Program. Because if you do, then you actually have a substantially equivalent to HUD in your jurisdiction. You have a substantially equivalent to HUD. And that's going to be important because that means those complaints that come in can be investigated. The resolution and being able to utilize conciliation, that is a resource and an avenue that's available to you. Otherwise, if you did not, the federal government, specifically HUD's Office of Fair Housing Equal Opportunity, they are responsible for actually receiving those complaints, investigating those, and where appropriate, conciliating those complaints. So that means that you have this asset, this resource here at the local level. Let me also share something with you. By the fact that you also have those resources, they don't cost you anything. It don't cost you a dime. It doesn't cost you a dime to file a complaint with the respective FAP agency and have that complaint investigated if your clients believe that their rights have been violated. So it doesn't cost any money to do that. I mean, that's a powerful resource because, as I share with you, only 35 states out of the 50 states actually have a state FAP. And when we're talking about the thousands of jurisdictions across the country, well, 700 jurisdictions that are entitlement jurisdictions, but all the jurisdictions, because there are thousands of jurisdictions, there are over 3,000 public housing authorities, if I'm not mistaken, that would be subject to that. Then that protection doesn't exist. You don't have a partner to be able to be educated by, who keeps you and helps and assists you be compliant with the law. But what's most important is that those persons who are protected by the law, who are the people we serve, they don't have the resources and access to the administrative process because there isn't a FAP. So that's something I want to kind of start with. The next part of this, and then I'm going to move back, is that as a part of that dialogue, the conciliation, that is, the bringing the parties together to try to resolve a complaint, it differs from the mediation process, because the mediation process, which I'm aware that a number of you actually have, it doesn't actually have what's called public interest relief in it. That means that when we're talking about a conciliation, one of the clear ways in which it differs from a mediation program is that you as an agency, that administrative agency, the City of Austin, Texas Workforce Commission, you are a party to this transaction. And we say, what? Wait a minute, bow tie guy. I thought this would typically be an issue between the respondent, that's the person or entity that allegedly has violated the Fair Housing Act or the local ordinance or state statute, and the complainant, though that person or persons who believes that their rights have been violated. That it's just between those two parties. Well, no, it isn't. The public interest relief is actually steps that are taking place. These are provisions of an agreement that are put forth to actually prohibit the alleged act of discrimination from occurring again, and fortunately stopping it from actually impacting or having a much larger impact or broader impact. Because you can imagine that if one act of discrimination a person is experiencing, he was speaking a lot obviously about disability issues, it's not going to be just unique to that person. It's not going to be unique to that person. Other persons who are of that protected class are going to come across that same circumstance or situation, and though relief can be sought through the administrative process for that individual person, it is through the public interest relief that you can that broader impact, that broader protection can actually emerge and can take place. So I want you to understand that just by the fact that you actually have an entity that has this power and authority, you have some protections that a lot of other jurisdictions do not have. Okay? So with that, let's proceed. So what conciliation? I told you a little bit about conciliation. I want to hear from you all. What's the purpose or what's the value of conciliation? Anyone? Guess what? Yes, I am going to do it because I have a lab little mic, so I'm going to come down here. Yes. Because it enables neither party to be found at fault. That's right. It enables, I'll say again, I'll restate it. It enables neither party to be found at fault. It's a way of preserving the relationship. Thank you. Others, anyone else? So it brings those parties together that were actually maybe at different vantage points on a particular issue, bringing them together to be able to resolve the issue. The point of it also is to actually arrive at terms that allows the person who brought the complaint or the persons that brought the complaint to be able to continue residing in the housing. That typically is the case. Now, there are some situations in which the person says, no, this is untenable. I need to be released from my lease. I need to be released from this transaction. But what it does is it preserves that. It preserves that opportunity and allows the person to move forward. The other part I would say the value of conciliating is you have an agreement that results from it. And having that agreement as a conciliation agreement or settlement agreement, there have been some instances in which there might be a VCA, voluntary compliance agreement in that regard. But what it does is it actually documents and says, okay, well, here are the issues and the violations that we had. Here are the terms, here are the conditions that we're setting forth to ensure that this person is actually, that there are violations and the issues, the harm has been addressed, because you're doing that in the conciliation agreement. You're addressing the harm that was done without assessing fault, but you're also in that public interest relief taking steps and putting in measures and features of that agreement that actually provide a protection that's much broader than that. And what it does also is that when that person actually comes to you as an agency and there is that conciliation that's put together, it's something that can be enforced later if there are future violations that take place. I'm going to restate that again because that's really important. It's actually, there are features in this agreement, this conciliation agreement. Once it's arrived at, what it does is it ensures that the discrimination won't occur again with the person that's experiencing it, but also it provides a much broader protection in that all the persons who are similarly situated, but it then allows the agency to actually, the administrative agency, to actually enforce provisions of that agreement to ensure that it doesn't happen again. Now, that's going to be important. I may as well kind of spoil some of the stuff I'm going to talk about later, which is that's important because if there is a private agreement between the parties, let's say the alleged act of discrimination is taking place, they meet and they talk about it, and they arrive at an agreement. They say, okay, well, these terms and conditions, we can abide by that as a respondent, complainant, are you okay with that? If that agreement is actually just made between those two parties, that's not enforceable at a later point. Not enforceable at a later point. So going through the administrative process really is a way of safeguarding not only that individual who's actually experienced the alleged act of discrimination, but it also provides protection and a means to monitor and enforce the terms that are actually a part of that agreement. That's pretty powerful. That is pretty powerful, especially when you actually sister with that the things that you can actually request and get in a conciliation that you could never get a court to order. What? What did you say, Bowtie Guy? There are things that you can get, features of an agreement that can be agreed upon in a conciliation that you could never get the courts to agree to. That's powerful. And it doesn't cost a person anything to do that. I think that's very powerful. So, is there an inherent value in conducting an investigation? I'll answer it for you. Of course there is. You see that, I'll offer this to you, and I like to use this as an example. When I'm trading, I actually refer to those who are a part of the civil rights infrastructure. You are the civil rights cops. You are the fair housing law enforcement professionals. You are part of that infrastructure. So imagine on the criminal law enforcement side, and there are many of you who are actually who have been former members of criminal law enforcement. Imagine if you're in an environment in which all those persons who are we're going to talk about criminal investigations right at this point. Imagine if those who were alleged perpetrators of crime knew that there was no recourse, there was not going to be any hindrance, any policing, any deterrent, that's the word I was looking for, any deterrent to them engaging in lawless behavior. What do you think would happen if all the criminals knew for 30 days, I'm gonna make it easier, 90 days, 3 months, the cops were not gonna be enforcing the law at all? What do you think would happen? You better stay inside. You better stay inside. Do you think minor offenses would or do you think those more serious capital offenses would actually, we would see an increase in that? We're seeing an increase in that. That's right. And the worst kind of most violent, gratuitous kind of examples of violation of the criminal law. Well, again, this is, the need for civil rights enforcement and civil rights investigation, fair housing specifically in this context, because if we did not have the enforcement taking place, if we didn't have the protections that the local law, that the state law actually provides and the federal law provides, we would see that lawlessness and noncompliance in the fair housing context. But we don't have to imagine what that looks like, because prior to 1968, that was the case. We saw segregation perpetuated. We saw people being denied access to, protected classes being denied access to transactions, and then whether it's wealth, whether it's housing opportunities, whether it's mortgages, we will be prohibited from doing that. So there's an inherent value to conducting investigations, because I will also say, and this is not an investigation class, but I will say that it's important because if I didn't, there are going to be some complaints of investigation, some allegations of investigation, some allegations of fair housing violations, that if we didn't investigate them from an agency standpoint, if you didn't have agencies that were actually had the role and responsibility to conduct these investigations, these things would just continue to perpetuate segregation, discrimination on their own. So again, there is an inherent value to actually conduct an investigation. However, in terms of conciliation, it allows parties, because that's a part of this process, it allows parties to be heard. And it's allowing parties to be heard. You'd be amazed that when you're bringing these parties together, they may have actually had an amenable and pleasant relationship prior to the alleged act of discrimination. Well, this is a way in which you're bringing them together when possible and when appropriate, because there are going to be some circumstances, domestic violence I can think of immediately, in which it would not be appropriate to actually bring, if there's a perpetration of sexual harassment, that would be another example of victims of domestic violence and sexual harassment. Those would be circumstances that may be best to kind of caucus and meet with parties separately versus trying to bring them together. But you would be amazed that in the conciliation, which actually begins at the beginning of the process, when a complaint is filed, bringing those parties together, people being able to hear the story from the other side, the other person's position, how that can often dissolve any barriers that people had and say, wait a minute, I didn't think about it from that vantage point. I now see the respondent's position on this. I now see the complainant's position on this. We're not that kind of business. We don't want to be seen that way in the community. We don't want our residents to have that kind of experience. We don't want those borrowers that come to us to actually have this in the back of their minds, because this has a reputational risk to us as a business when people hear that we violate the Fair Housing Act and that we're not trying to work with people and comply with the laws. It allows for quick resolution of the complaint, and again, as I said, it avoids protracted litigation. It explores creative options. Again, I shared with you earlier, in a conciliation, when you're bringing these parties together to resolve a complaint, you may be surprised at the concessions that can actually be arrived at in this process. So I'll give you just a quick example of that. And we'll speak on the issue of disability because we were just speaking about this. So this person was actually residing in a particular apartment complex and they became disabled. The house was, the structure was not exempt, so therefore an investigation could move forward. And the person was making a reasonable accommodation request because they could not actually fully utilize their home, specifically the restroom, the bathroom. They couldn't utilize their home. Well, it took the management company and the owner of the property a very long time to respond to the request for this reasonable modification. A very long time. Very long time. I'm not talking about 30 days or 60 days. This person says, look, I don't have access to my bathroom. I'm disabled now. I have documentation that I'm disabled. I'm making this request. I'm willing to pay for this modification on my own. Please let me do this. They were very, very slow to respond. I would say non-responsive, as a matter of fact, because it said justice delayed is justice denied. In this case, if you're thinking about a person who can't really fully use their restroom for a 12-month period, that's a long time. That's a long time. So after the complaint was filed, with the help of a FIP, the complaint was brought to us. When we looked at it, we were like, well, wait a minute, this should have been something very easy to resolve. Well, we brought the parties were brought together. The owner of the property was unaware of this issue. And the owner said, no, in the middle of it, said, no, we're not gonna actually, that's not how we do business. That's not how, I can't sleep, I'm not gonna be able to sleep at night knowing that this person did not have full use of a property that they're paying rent to me on. So one of the concessions that was asked, the person was asking for rent to be waived for, I think it was like a 3-month time period. The owner said, no, we're gonna give you a full year's worth of rent that is unpaid because we were unresponsive to you. You couldn't get a court to order that. And guess what it did? It preserved the relationship. The person was able to stay there and continue staying there. So again, those are the kinds of things that we can get out of, and that's what we're thinking about when we talk about that justice part of that. To the extent possible that we can, making that person whole, to the extent possible. Agreements can contain remedies that can never be ordered, which I just remarked about a moment ago, and preserving of the relationships. You're in a very, if you look across, Austin, as well as, Houston, Dallas, these, also the smaller parts and rural parts of your community are all subject to the same thing that is actually happening, not just in the United States, but across the world. In terms of affordable housing, it's very difficult to find safe, decent, affordable housing. So when people find it, when a families with children finds a 3-bedroom or 4-bedroom, they're not trying to give that up. They're not trying to move from it. because it's going to be very difficult for them to be able to find housing that's suitable, that actually meets all their needs. And maybe it's in proximity to the children's school. It's in proximity to family members' medical services. It's in proximity to the place of employment. So people are usually not trying to give that up. So to know that there is a part in the administrative process when we're dealing with fair housing, that people often, when you hear fair housing, people often, especially on housing provider side, people clench up, it's like, okay, wait, they're in the room. We got to watch what we say. Well, to think that there is actually, in the fair housing administrative process, there is room, there is space, there is actually the option of conciliating a case in which we can actually not do any harm. We can do things to actually preserve those relationships. And again, that powerful opportunity through conciliation is something I'm talking about today and something I want you to be able to avail yourselves to. So, in fair housing, in terms of conciliation, it's a voluntary process. So that means that the parties are entering into that, and the agreement says so. It says such. It's mandated, as I shared with you, by the Fair Housing Act, and I'm going to show you in the Fair Housing Act and also in the Code of Federal Regulations where it is actually this, the mandate to conciliate is there. So it's a part of the process. That's a part of that justice denied part. If you are not in a situation in which conciliation is not being offered to the person at the beginning, in the middle, and at the end of the investigative process, that's a justice issue in my mind. That's a justice issue because this issue or fair housing matter could have been resolved very early into the process if conciliation was offered. Conciliation was offered. Mandated by the Code of Federal Regulations, as I remarked about a moment ago, the value to all parties resolving the alleged discrimination and form alternative dispute resolutions used through the legal system. Something that I found in terms of the valuable to all parties resolving the allegation of discrimination. We've had respondents that actually view, even though at first when they got the complaint, they didn't feel this way, but they view that, wait a minute, the conciliation, my name's not going to be broadcasted all throughout the community saying I'm a bad landlord, I'm a bad actor in the community. We've actually seen some respondents use this as a means of kind of promoting their respective agency. We now are compliant. We welcome families with children. We are a place in which you want to live. You will also see often their signage and the advertisement change after that. Being more inclusive, letting more people know that you are welcome here and that you're permitted to actually live here in our wonderful place or space in the built environment. So again, thinking about it from that way, it's much easier to arrive at that in the conciliation process than it would be once the agency has actually conducted its investigation, arrived at a reasonable cause determination, because at that point it does, by the nature of it, it feels a bit more adversarial because it is at that point. So, mandated underneath the Fair Housing Act. I'm going to move through this very quickly. I shared with you all. It's in the definitions. That's where that 42 United States Code of the Fair Housing Act. Again, not a lawyer. You got a person who's not a lawyer up here citing the law. You can do this as well. It is available for you. You can use the state law. You can use the local ordinance and become familiar with it and be familiar with what the city of Austin actually requires. Underneath the Fair Housing Act, that is. It's actually, those definitions of conciliation are actually found in 802L and M definitions. 804C, conciliations are to be held where the allegation has occurred. So again, because you have, at present, we're talking about two FRAP programs that are present, the City of Austin and the Texas Workforce Commission. That means that HUD on high is not investigating these cases, even though there is a regional office that's here. You're in a place in which those persons who know the market, who are known to the housing professionals because they may have educated them, they may have actually engaged in education outreach campaigns, they previously may be aware, they've come to conferences such as this, they may be familiar with those persons, and so it's a bit easier for them to actually, those complaints to be investigated and also resolved with persons who are locally on the ground. So that's going to be important. It says under 810, this is under 42 United States Code, 810B, 1, 2, 3, and 4. This deals with the investigative report and conciliation. This goes back to that annual report that I was remarking about that HUD FHUO puts out every year. Usually every year they put it out. But if you look into that, it actually has a lot of information about all the complaints that are processed across the country. You can find out and look at the state of Texas and see the number of complaints that all the FAPs, as well as the FIPS, but specifically the FAPs, how they have actually resolved and investigated those complaints. I'm remarkable about the FIPS because the FIPS often are filing complaints with the administrative agency or with HUD. But again, that report I found is very powerful because the information that is gathered by the local, that information that's gathered by the local FAP, that means those complaints that have been intake that have become perfected complaints, that information is aggregated and actually reported up to HUD headquarters, FHEO, Fair Housing Equal Opportunity Office, and then all that information is compiled, that data is compiled and actually used to produce and publish the annual report. So my suggestion to everyone, again, I would pull it up and we would go through it, but nope, time doesn't permit that. So 810 possible arbitration and possibility of binding arbitration. I haven't seen much of that in my 27 years of conducting these investigations. However, it's typically, if you're talking about most lease agreements and other agreements between lenders, insurance providers, they usually have that binding arbitration clause that's in there. And then 810C, failure to comply with agreement. So I remember I remarked about that earlier, that there's recourse, that if a person or entity, respondent, person who allegedly violated the Fair Housing Act, if they do not comply with this conciliation agreement or voluntary compliance agreement, that there's actually actions that can be taken. There's monitoring that is taking place for a certain duration of time in these agreements. The private agreements, as I remarked about earlier, when you have those circumstances in which the complainant and the respondent come together outside of the administrative process, and the respondent says, okay, well, look, let's just resolve this here. We don't have to go much further with this. If he, she, they, respondent, do not comply with the agreement, there's no way to really enforce that. There's no way to enforce that. That's a problem. And that's a problem on that individual level. The macro, moving to meso macro, because that's the micro problem, individual, but moving to the meso and macro, that means that the act of discrimination is going to be undeterred. That means that, so you can expect to see that complaint again. You can expect to see it again. So that's the reason why conciliation is such an important part. So let's move on. The mandate is at 810. I'm going to move through this because, again, this is just affirming the whole, the purpose of conciliation. That's in the Act, the Fair Housing Act as amended, that is also in the Code of Federal Regulations, and also in the HUD Title 8 Handbook, Chapter 11, there's actually a dedicated chapter that deals with conciliation. And that's the part that we teach out of when we're actually part of what we teach out of. So you heard me just remark about a moment ago, 814, well, I say this in the Fair Housing Act, it's at 814 B2A, and that's enforcement by the Attorney General, or again, that's going to be the equivalent at the state level or at the city level. The Fair Housing Act, Regulation 24 CFR Part 103, Subpart 103.300-335. Also, the Code of Federal Regulations 103.300. 24 CFR 115, that deals with the FAP program, excuse me, and 115.206 D4, that's performance review. That's something that the FAPs have to go through on a regular routine basis. And then Chapter 11 of the HUD Title 8 Handbook. This is available to everyone. You can actually do a search of HUD Title 8 Handbook. You can actually, I would say it's enjoyable reading for those who love fair housing in that regard. But if not, you can come to one of our classes. And then conciliation to be attempted throughout the process. So we said, bow tie guy, where does it say that? I'm glad you asked. So it's codified in the Fair Housing Act, and this is 810B1, and it says, during the period beginning with the filing of a fair housing complaint and ending with the filing of a charge or dismissal by the secretary. And again, when it says secretary, speaking about the enforcement agencies, and we say this in the training, your agency, you are acting and serving as the secretary. The secretary shall, to the extent feasible, engage in conciliation with respect to such complaint. So And again, in the regulation says something similar. State and local agencies, with the filing of a complaint and ending with the filing of a charge or dismissal, the agency will, to the extent feasible, attempt to conciliate the complaint after a charge has been issued to the agency. Will, to the extent feasible, continue to attempt settlement until a hearing or a judicial proceeding has begun. So what that in kind of plain spoke is, when the person files a complaint initially, and the intake officer hears, like, wait a minute, this person has actually made out those 4 elements of jurisdiction. That's what makes a simple allegation become a perfected complaint. And again, that's going to be standing, timeliness, the respondent covered, the dwelling covered, and then subject matter. So once the intake officer hears, they hears that information, I got to perfect the complaint now. I got a complaint that actually I can move through the administrative process. We teach in the academy and in our courses that once you have arrived at, you have a perfected complaint, that's an opportunity for you to begin tacit conciliation. Tacit conciliation. Well, what do you mean, bow tie guy? When I say tacit conciliation, you can educate them about, well, throughout this process, here's what's going to take place. In intake, it's going to move from intake. Once we get certain information from you, it then moves from the intake stage to the investigative stage. In the investigative stage, this complaint is going to be assigned to an investigator. He, she, they are going to be interviewing you, collecting information from you, to your witnesses, from your witnesses as well, the respondents' witnesses. They're going to be compiling that information, this evidence, to actually utilize it and applying what are the prima facie, prima facie. I'm from the South, so it's Latin. I'm not sure which one is right. But prima facie, prima facie case, those elements to see whether or not an act of discrimination is taking place. So they explain it, and then they say if it has arrived at that, then if a reasonable cause determination is arrived at, we then can prosecute that underneath our respective law. In that, and after they say that, they also can say and should say, that's an overview of the process. We're going to be sending you out correspondence that reflect that, but we want to know, what are you seeking? What are you seeking? Now, as an administrative agency, you're not making any promises. You're not saying, okay, yeah, we're going to be able, that, you want $1 million? Yeah, we're going to, no, you're not, that's not, we're not doing that. No, what you're doing is you're asking the person, what are you seeking? When you filed this complaint, what was your goal? What were you trying to do? Well, and what do you think some of the typical responses are when people file a complaint? What do you think some of the responses are? $1 million, that's right. Thank you, Ms. Rose. Thank you, Ms. Rose. That's right, $1 million. Of course, $1 million. No. I mean, if the damage is there, but now we're gonna give you the worksheet, which we're gonna talk about in a little bit. But no, they're gonna have to fill out the worksheet, fill out the damages worksheet, fill out the emotional damages worksheet, the actual damages worksheet. But what are some of the other things that you think people would say when the act of discrimination is taking place and they're filing this complaint with the city of Austin or they're filing with the Texas Workforce Commission? What do you think they're trying to do? Often? Injunctive relief, that's right. They need to know that they can't do this and they need to be trained. I want to make sure that this doesn't happen to someone else. I want to make sure that someone else doesn't, I'm injured in this. I want to make sure others are not injured in this. And so what that does is that moves to one of the most common responses is, I don't want this to happen to anyone else. I don't want this to happen to my children. I don't want this to happen to anyone else who's interested in trying to live here. So again, that's something that we can do, just simply asking people at the beginning, not making any promises or assurances that we're gonna resolve this and you're gonna get that $1 million. No, that's not what we're doing. But what you are doing is at the end of the intake, you're asking the person, so what are you seeking? What are you seeking? And you will find that many people just want to be heard. They just want to be heard. Like, I called 5 agencies. One of them hung up in my face. These are things that people have said to me. One of them, I don't know if it was government or nonprofit, but somebody hung up in my face. That's offensive. And so the fact that you sat and listened, again, there has to be parameters of the listening in terms of you have to say to the person, I don't have 2 hours to actually, or 3 hours or the rest of my day to actually, or, every time you call, I'm not picking up the phone. You've called an agency. We have other people that work here. We have, a labor force that works here. So, but being able to just be heard, we have found and we've heard a lot of people are just asking for that. However, you can get more out of the process, obviously, in the conciliation process. So let's talk about that. So the different modes of conciliation, let me just look at my time here. Okay, good, I got 30 minutes left. Excuse me. So the different modes of conciliation, I want you to be aware, depending upon, this is also helpful for those of us who are in the administrative process and those who are subject to it, who would be filing complaints or who are respondents who would be subject to it as well. So being aware that different agencies are structured because of their staffing, they're different. So some of your larger agencies, your larger fair housing assistance agencies, they have separate staff that can do different things. I'm aware of some of you who are present, anyone that actually, a certain group of people, everyone's trained on mediation. I'm aware that some FAPs that everyone first must do intake first, and then they get moved to other roles in the respective process. However, there are other agencies that aren't as large, and those smaller agencies, you may have 2 people and they're doing everything. They're doing the intake, they're doing the investigation, they're doing the conciliation. Now, there are parameters. The Fair Housing Act ponders it. The Title 8 Handbook, Chapter 11, that deals with conciliation, ponders that. So I don't want you to be in a situation in which if you're dealing with a person, a small agency, or not, or maybe not such a small agency, in which the person who did the intake is now the person who's actually conciliating the case. And you're like, wait a minute, something strange about that. No, it's pondered by the handbook, it's permitted by the handbook. However, there are going to be safeguards that have to be undertaken in order to make sure that anything that is actually gathered in the course of the investigation, that you're not anything that's actually found out in the conciliation cannot be used as a part of the investigation. I'm going to restate that again. Any information that is actually found out in the conciliation cannot be used as a part of investigation. So I'll give an example to make that very clear. So let's say that you're in a conciliation, you want to demark that you are in a conciliation. You want to say, okay, I've just finished the intake on you. We're going to transfer you now to investigations. The investigator is going to actually reach out to you. He, she, they are going to reach out to you. So you hear from the investigator says, yes, hi, I'm Jeffrey May. I'm going to be the investigator that's assigned to your case. I just need to, fact check a couple of things with you. I am going to be making a request. Did you get our request for information or our interrogatory request? Did you get that request for information? Oh, you did? Great. Any of that information, please send it to me as well. I do want you to be aware of that you also need to be offered conciliation in this process. So what I'd like to do is set dates that are available in the future, a date in the future that I can actually have a discussion with you if you're open to it and if the respondent's open to it, to conciliating the case. So once I've done that, I'm doing that because I'm letting the person understand, and I'm going to say, look, the intake and the investigation is separate from the conciliation, even though it may be being conducted by the same person. Let me restate that again. Your intake and your investigation are separate from the conciliation, even if it's being conducted by the same person, being undertaken by the same person. So, in the case of things that are found on conciliation that you can't use in the course of investigation. So, there's a situation in which the person, where the conciliation is taking place, and the complainant, shares some information or says something that apparently triggered the respondent. And the respondent, on the allegations that the respondent had violated the Fair Housing Act, had done something, and, was asked, so, okay, well, the complainant just said this. Is this true? Now, granted, this isn't fact-finding. We're not trying to debate the merits of the case. That's not what's happening. People are sharing their perspective and trying to resolve the complaint. Well, apparently this triggered the respondent. The respondent said, I told her not to do that. And if she did it again, I'm going to serve her with eviction and put her out again. We all quiet, like, okay. She just admitted that she did it, that she violated the law, right? So, what do I do with that? Well, Fair Housing Act says, and then the handbook says, no, anything that was said in the course of the conciliation cannot be used as part of the investigation. So it's, it's one of those things. Once that bell is rung, it's really kind of difficult to unring that bell. Can you imagine? However, you cannot use that on April 5th, April 16th at 4:03 p.m. Respondent said yes, admitted to doing that. You can't do that. You can't do that. What you're going to have to do is, in the course of your investigation, you're going to have to find the evidence that actually supports that this is taking place. You can't use his, her, or their words if they said it in the course of a conciliation. If it's in the course of an interview dealing with the investigation, and they say, yeah, we did that. Our policies do this, and we don't. No, that's evidence can be used in using you arriving at a reasonable cause determination. But if it's said in the conciliation, you cannot. So these different models. So we have, in some instances, I share with you, there's a dedicated conciliator in your agency. I would say the strength on that is that the more you do something, the better you're going to be at it. The more you do something, the better you're going to be at it. HUD has, and this gentleman has long ago, he's retired and passed away, but HUD had an amazing conciliator. Because he was so good that they would pull him to different regions to actually conciliate cases, because he was just that good. However, the issue with that is if I'm a small agency, I don't have the staffing. I don't have the bandwidth to be able to do that. I'll be in a situation in which cases, if I had one dedicated conciliator, or that's all I did exclusively, there's a lot of work that I'm not going to be able to do. And in some instances, I may have to actually refer those cases and remand them back to HUD because we just don't have the staffing to do. That said, conciliator who is not the investigator. So you can have, and often you have, staff at administrative agencies, enforcement agencies that have multiple roles. So I was the person who did the intake, but I'm not the one who's going to conduct the investigation of your complaint. I'm the one who's actually conducting an investigation of your complaint, but I'm not going to be your conciliator. It's going to be someone else. That's all permitted by the Title VIII handbook. The conciliator who investigated the case. So when we're talking about conciliator who investigated a case, and cautions when a conciliator is the investigator of the case. So you're going to need to separate those responsibilities, those duties. I'd like to demark it. I like to say and announce it, sort of like when you're opening hearings, when you all in your administrative process, or when you're opening your investigation and you're first talking and engaging the complainant or respondent. You're saying, I'm Jeffrey May. The time is now 4:05 p.m. on April 16th. We are now going to commence our conciliation. We're now going to commence. Okay, the time is now 4:06 on April 16th. We're now going to close the conciliation. We're doing this because I want to be able to have that clear, distinct line in the sand that everyone understands we're in conciliation, we're not in conciliation. And why is that important? Because something I said a moment ago, anything that is actually said in the course of the conciliation cannot be used as a part of the investigation. I want you to be aware, and again, respondents and complainants both, it could be that they unintentionally did something like this, or they intentionally did something such as commingle information and when it's shared. So what do you mean, Bowtie Guy? So if I'm in a situation in which I'm communicating with everyone via email, one thread, when I'm actually asking for information about conciliation, I'm going to be very clear in the header. This is for conciliation purposes only. Conciliation purposes only. Use this email thread only for that. I send that email off, give them instructions, ask them for times in which they're available to do certain things. 2 days later, they actually are responding to something, not to conciliation, but they're responding to another request, or they thought of some additional information or witness that I needed to interview. And what do? This is human nature, it happens. Mistakes happen, but it may not be a mistake. They will actually use the thread, the conciliation thread, only thread, to respond to a question that I had in the course of the investigation. That's a problem. Yes.
So at the conclusion of the investigation, I assume there's probably findings
Yes.
or a general summary of what went down.
That's correct.
Right?
Yes.
That's what you're basing the conciliation on.
No, the conciliation is based on, the conciliation is based on just simply trying to resolve the complaint. It is not looking at the merits of the case. It's no fault at that point. It's like, this is how we preserve this relationship. Now, what's interesting about that is that actually once I conduct my investigation and arrive at a reasonable cause determination because the evidence has led me there, I can still conciliate. In fact, that's usually what happens. It's usually what's happening. Like, okay, these findings are here. We arrived at this. However, we're going to still give you a last attempt to conciliate. Again, most judges are going to want to know that. They're going to be like, did y'all try to work this out again before you come to me? Because neither of you are going to be happy with what I arrive at, probably. So, thank you for that question. That's a good question. So when you're dealing with, and I'm the investigator, I'm the conciliator, and I'm the one who's also investigating the case, it's going to be important that you actually demarcate, make it clear, stamp it in such a way that all parties know that I'm in conciliation right now, I'm not in investigation. When they use that thread, that example I just gave about the person responding to the email that said conciliation, for conciliation purposes only, redirect him, her, or them. I'm sorry. This email is only to be used for conciliation purposes. If you have any questions or you have evidence that you want to share with us, please respond, and in the heading, identify that this is as a part of your investigation. Put the name of your case, and things like that. Give them instructions so it's clear that the email that is coming to you is not a part of the conciliation. You want to be clear about that. Same thing in terms of phone calls as well. You want to be clear when you're having that phone call. When you're setting up that date, you're scheduling it. Okay, I'm going to schedule this time to speak with you and get information in the course of the investigation. I'm now going to, on this separate date, set up a time for us to actually conduct the conciliation. You want to be clear about that. You want to be clear to all parties. You want to then send out correspondence that reflects that. You don't want to be in a situation in which the person is going down the road, and at some point, if you arrive at a reasonable no cause determination or a reasonable cause determination, and the person says, well, I have issues with this investigation because the information that you shared and you stated that was the basis of your investigation, arriving at this reasonable cause or reasonable no cause, was information that I shared in the conciliation process. All of a sudden, instead of the facts of the case that are in dispute being showcased and being investigated, you don't want to be in a position that now your agency is actually now the subject of that. You do not want that. So separate those things. Make it very clear, I'm in the investigation here. Okay, we are now going to schedule and make it very clear that we're in the conciliation process. Okay. So moving on, and let me say my time, because I want to talk more about in terms of the relief and justice part of this as well. So separating the conciliation it says the stuff that I just said here, which is concluding an investigation interview that takes place prior to engaging in conciliation, take a break prior to the conciliation. Taking a break, I'm saying doing something to make it very clear that you are now, again, did you all hear when I did that announcing? When you're opening up the hearing. At this time, I like to timestamp everything. Time is now 4:09 p.m. on April 16th. We are now commencing the conciliation. The time is now 4:16 on 4:16. We are now going to we're going to end the conciliation right now, so that everyone's clear of what's happening. Initiating separate phone calls only in which conciliations are discussed. As I said, same thing in terms of your email thread. Verbally announcing the parties at the transition to conciliation and fully expecting the difference in the roles and functions of the investigator and conciliator. Example, that anything that's said or done during the conciliation cannot be used in the investigation. You need to take steps to avoid commingling notes related to investigation and conciliation. Yes, Ms. Rose.
When I do the conciliation part, I just let them know this is conciliation and what are you asking for?
Yes.
Or then if I'm doing it with respondents, okay, what would you like to offer?
Yes.
So we don't get involved in the investigation. I just want to know what
We-
terms.
That's
No investigation is brought up or talked about.
being very clear about that. That's correct. That's what I would do. I would even, my point of it is scheduling it separately if you could. Sounds like what you were just describing is caucusing. meaning that I'm talking to one party separately. I'm not bringing the parties together. I'm then communicating and relaying the information to the other party. I think that that's wise because what it does is it makes it very clear that we actually are in conciliation when we do that, making it very clear. Sometimes you have to do that. Remember, I mentioned earlier victims of domestic violence and sexual harassment situations. You do not want to be doing anything that's going to be injurious to either party, but especially those persons who are victims of domestic violence or who may have been the subject of the sexual harassment. By putting them in the same room, even if you're talking about on Zoom or WebEx or even Skype, seeing the person can be something that triggers the person. So you want to make sure, again, you're not doing any harm in that respect as well. So you want to be mindful of that. So, okay. Models of it, we have, as we marked about, the in-person, conference call, and conciliator goes back and forth. That's the shuttling or the caucusing, and what are the advantages and disadvantages. So, in the pandemic, obviously we were doing a lot of conference calling. We probably still are. Depending upon the size of your jurisdiction, you may be required. You just don't have the ability to be able to do that. Texas is a very big state. It's a very big state. That being said, so being able to do in-person conciliations has its challenges in that sense if I'm in a very large jurisdiction. It also can be a challenge if there's some clear animosity that exists between the parties. You do not want to be in a situation in which, if someone's, if it's like oil and water and you're putting them in the room and that's going to just be volatile, or it's like a better example is you do not want gas and a lit match. You don't want them to, to have in contact with one another. Even if you are in a building in which there's security, you're not trying to do anything that's going to be injurious to the parties. You don't want to do anything that's going to be disruptive to the process. So you want to be mindful of that. The benefit of being able to do the in-person is that there can be an opportunity when someone they hear the different perspective, the other perspective, that empathy that can come out of that. The person said, okay, I didn't think about it that way. They're seeing the person's response. They're seeing how they're behaving. They become, they become moved by that. That can be a benefit in that respect, in that regard. So again, in person, you want to be able to control the environment as much as possible, and you are the person in control. I want to be clear about that as conciliator. You're the person who's actually convening the people. You're the person who's actually setting the parameters. You're saying things such as, everyone will be making statements directly to me. No one is actually going to be using any inflammatory language, no yelling. If at some point I see things are becoming volatile or hostile in any way, I have the right to stop this at any time. Stop this at any time. If you think, if necessary, and I know that some agencies have this because of where they're located, having security or, say, police on hand close by if you're aware that there's a circumstance in which there's a potential for some, to turn acrimony can turn to volatility. You want to make sure that that you're safeguarding those things. Also, in person can help with resolving it faster. It puts people in a situation in which they're hearing one another. There are some of your colleagues that as soon as the terms and conditions are arrived at, they can actually produce that conciliation agreement that day. Have all parties sign it. They still have the opportunity, sort of like when you're dealing with an agreement when you buy your home, there's a few days of rescission that they can say back, I want to come back and think about this. But what it does is it permits an agreement to be arrived at much faster when you're in person. Conference calls, again, you can have both parties present, treated very similar to the way that you would do an in-person conciliation. But I do want to also, again, there are some things that can get kind of lost in translation. The person does have the option. You can't require them to actually be on screen. So, that being able to mask, what I'm thinking, what's happening, that could be, because, this happens, the caucusing amongst, especially if you're dealing with respondents and it can happen with complainants too, but their counsel actually putting things on mute, taking the person off screen, and they're caucusing and saying, well, no, you need to dig in a little harder with that, or really this is how you need to change your position. So being able to actually have the conference call, I would say that can be a drawback. Yes, Ms. Neal.
Okay, going back to your earlier example, you had an owner who had not been aware.
That's right.
You've been dealing with a property manager.
That's right.
So how do you get the right parties to be part of the process?
Outstanding.
When the owner got involved, things got, but the manager had obviously, not been communicating.
Outstanding. Well, it's something that's a part of the investigation. It happens initially at intake. Intake is actually, so who is the person who allegedly engaged in the discriminatory behavior, the alleged discriminatory behavior? You write down to everybody. And that's what that's what I tell the investigators or the intake officers, write down to everybody. Write down to everybody. Now, some of you housing providers are like, wait a minute, write down everybody. Well, through the process of elimination, we will be able to say, okay, well, no, you're not a party to this. And again, we can remove you as a party. It becomes a problem for the administrative agency if I have not identified all of the persons who've allegedly engaged in a discriminatory behavior. Because if I don't, and I do this later in the process, and I have knowledge that this particular person or entity is an alleged respondent, it now does something in which I have to give that person 10 days, I have to give them notice, put them on notice, and then I have to give them time to respond. That's going to impact my timeline for investigating my case. So I need to, from the beginning and as soon as possible, list everyone who potentially is a respondent in this circumstance. At some point, if it's determined, okay, wait a minute, you're not an appropriate party, it's much easier to have that person and dismiss them as a party than it would be to add them, because that's going to impact my timeline to investigate my complaint. So, in terms of, going the last part in terms of the conference call, I mean, we can also remember that at the time in which, we just simply called everyone. And when you're doing that, you can put them on a conference call, and you could call everyone, and you can even do this via email. That's kind of something that's shuttling, the shuffling between the parties. I mean, the advantage of that is that if there is some hostility amongst the party, it gets dissolved. You're not transferring any of that, excuse me, at all. I would say the challenge with it is that means that the parties don't get an opportunity to hear one another, because it is being translated through the conciliator at that time. However, it can work in which the conciliation can work faster because everyone is expecting, and it's much cleaner because you're very clear about I'm conciliating between both of you. That's the thread that I actually have here. That's the purpose of this phone call versus, someone just calling you and sending you information in that regard. But again, I just wanted to explore that. There's more to it as well, but let's move on. Role of conciliator is to be neutral, fostering communication, handling the party's emotion, facilitate discussion, focusing on discussion around interests, resolving challenges, documents the process, and develops the terms and conditions. So the representatives, again, in terms of this, you have the complainant, that's the person who allegedly has experienced the discrimination, or persons that have allegedly experienced the discrimination. You have the respondent, these are the persons who have allegedly engaged in discriminatory agency. And then you have the agency. Now, again, so assuring right representations are at the table. Representations must be the authority, must have the authority to settle the matter. So when you think about attorneys, that's pretty clear. Once an attorney is actually in the process representing either complainant or respondent, you are to be communicating with those parties through that counsel, period. When you have an advocacy group, a Fair Housing Initiative Program, a FIP, a disability rights group, and they are assisting the person, they're advocating for that person, as long as they actually have a letter of authorization stating that they are the designated representative assisting the person in the process, you are to be engaging them and communicating with them. You can have situations in which those agencies are complainants. I'll say that again. You have situations in which those agencies, the disability rights groups, are complainants. The Fair Housing Initiative group is a complainant. So in those instances, they may be advocating for their client, but they also may have counsel and they also have their own complaint that's in the process as well. So just be aware of that. If representation is identified, the golden rule on this is that you need to be communicating. Thank you. Thank you. So, what are some of the barriers to conciliation? Fear of people. This is often, I would say, the respondent often feels this, but the complainant could feel this way as well. Fear of being perceived as being weak as a respondent, meaning that if I actually acquiesce to this and agree to actually conciliate, I'm going to have a line of people at my door with similar complaints or other complaints stating that their rights have been violated. Fear of conciliatory efforts to be rejected. Again, that's something that I feel like both respondent and complainants can feel that. Concern of being perceived as being the cause of the conflict. Again, that can be both complainant and the respondent that can have that. And concern that there will be other parties that might have unfair advantage or stand more to gain from the resolution. So again, going back to this issue of the justice part of this, I have seen many situations, unfortunately, in which the complainant, he, she, they are by themselves. The respondent has his or her attorney, the insurance company has their attorney, and the management company has their attorney. So you're talking about anywhere from 3 to 6 people on this side, and you're just dealing with the complainant on this side. That by itself, it appears, even if it's not said, it appears that there's an imbalance there of the power dynamic. So be mindful of that. That might be a situation in which it might be better to actually go and utilize the conference to kind of remove that power dynamic versus actually doing something that's in person. So I'm sorry about that. Okay, good. I can go ahead. So moving on, because I do want to kind of wrap up, and I want to just talk a bit more about the justice part, and then we can adjourn. So in terms of this issue of interest versus interest-based conciliation, so separating positions from interest, focus and identify interest. So as a respondent, let's take out the word respondent. As a housing provider, what are you doing? As a bank, a lender, mortgage, what are you doing? What are you doing? Why are you in business? Why are you in business if you're a housing provider? Make money. That's right. Is that a crime? No. In fact, it's the American way. We're based upon it. Legally lawful, being able to make money. As a person who is seeking a loan or who's seeking housing, what am I doing? What am I doing? What did it say? Say it. Trying to find a what? Place to live. That's right. Trying to place. So those are interests. Those are interests that actually that fit nicely together. Housing provider, person who needs housing. You bring them together. It's a wonderful union. That's the purpose of it. When you're doing your investigations, you want to focus on that. And I find that it's important to really have a clear understanding. Speak with the complainant. Really get an understanding of what he, she, they really want. Find out what they want. They're going to tell you, I want $1 million. Well, okay, that's what you want. But what are your needs? What are your needs? Well, I need to have a place to live. This place is close to my synagogue. This place is actually close to my job. Those are needs. Those are needs. Try to align, and this gets to that justice part. Try to align the needs and not simply the wants, because you may not ever get to the wants. You may never get to the wants. So, conciliation in various stages, early stage conciliation, and kind of I've touched on these things, but again, you need to be doing this at the very beginning once the complaint is filed. You also need to, at different points in investigation. I'm going to suggest there's not a number that's in the HUD Conciliation Handbook in Chapter 11, but it should take place at least 3 times. And don't do them back to back. Do it right at the beginning once the complaint comes in. Do it kind of midway through the investigation. And once you're about to resolve it, whatever it may be, that's going to be your opportunity to actually give them an opportunity. And tell them, let them know these things. Prepare for conciliation. Again, I feel like this is information I'm going to kind of move through this because I want to get to the end on this in terms of preparing for conciliation. One, you need to make sure you're familiar with the materials and that you've read the case. Find out as much as you can about the respondent and complainant. Now, that doesn't mean friending them on Facebook. Don't do that. No, you're messing up your investigation. You're moving into some bad ethical territory in that regard. But you need to make sure that you know them. With the parties, you want to obviously know what their different positions are and what their objectives are, needs versus wants. Identify the party's interests, have a resolution plan if you can. Talk with your peers. I'm big on case review. I'm big on that. Staff meetings, I'm big on that because you may learn something and hear something from your colleagues that you didn't know. Say, oh, ABC Management Company, we've had 5 complaints for them 3, 4, 10 years ago. They've, that same issue. So again, knowing whether or not, knowing more about your different respondents. Yes, ma'am.
I don't mean to be off topic, but can you just share, I seem to remember, like, we live in Austin.
Yes.
That Texas Workforce Commission doesn't take the complaint. Is that accurate? Like,
So,
the housing discrimination?
no, it's a good point. So the question is, you said Austin, you live in Austin, and that the complaint isn't taken by the Texas Workforce Commission. And that is, without inflammatory saying this, that's true. And why is that true? Because there is a local FAP, and again, something I had remarked about earlier is that HUD and in the regulations wants the complaint investigated as close to where the act of discrimination occurred. So since you have a substantial equivalent that's here already, the city of Austin, you're here, that complaint would actually be investigated and taken and received by them. If it goes to the Texas Workforce Commission, they would have to refer it to the city of Austin because you have a substantial equivalent that is here. So that's the reason why. It isn't because they don't like the complaint, it's because there is an agency that's already serving that jurisdiction, and there can't be any duplication there.
Now, if I may ask, the only complaint you take from Austin is conflict of interest.
Yeah.
And what you
Yeah.
would be referred to us by HUD.
Yep. Yeah, but it isn't because we don't like the city of Austin and their residents. No, it's because there is a local FAP, a substantial equivalent, that can handle that case, and they're funded to handle that case.
Thank you. Leslie, can you just share, is there a guide, like a script or case studies that are successful complaints that have been filed that the public can?
Yes, indeed. I would say, yes, there is. So the Department of Justice actually publishes, and the HUD's website, they publish all the complaints that they actually resolve. So I would start there first. I would go into the Department of Justice's website, type in Fair Housing Complaint Settlements. And there's a whole bunch of settlements that they've actually done. And it's chronology, so it's in a chronological order. So the most recent cases are at the top. And I will say that you've had some, and I'm getting pulled. There's been more aggressive investigation and conciliation than at different times and different time periods. I'm going to say this in my parting words, and we can talk more. This responsibility to investigate the fair housing complaints are going to be resting more heavily upon the FAPs. That's where we're going to be. In fact, some of you are super FAPs. That means that HUD is referring cases to you, not the other way around. So with that being said, be proud that you all have, in the city of Austin, in the Texas Workforce Commission, you have substantial equivalents that are able to investigate these cases, and they have the resources to do so. Sounds like my time is up. I'm now give the floor to Mr. Damon, and I'm going to shut this off so it doesn't squeak.
No, thank you. Can I get a round of applause, please? Thank you. All righty.